Thanks for coming. It was the inspired thought of the organizers of the conference to start off with student presentations, and so that means that my job is to stay out of the way and keep time. We're going to begin with Sam Brody with commentary, and then we'll move on to Garrett Ordauer. So my pleasure to introduce Sam Brody.
Thank you. Okay, well, I don't think I'll need that anyway. When Bush administration representatives are questioned about torture, their usual response is to condemn torture in general while denying or refusing to give an opinion about whether some specific practice, such as waterboarding, can be classified as torture. When supporters of the Bush administration's conduct of the war on terror are challenged on the issue of torture, one popular response is to raise the possibility of a radically exceptional case in which torture would be justified, usually the ticking time bomb case or one that resembles it, and thus to challenge the challenger in return. Both of these strategies, the exclusion of particular cases from a vague general definition of torture and the creation of a kind of paradigmatic exception that could justify torture, are good examples of casuistry, the case-based contextual form of reasoning that is characteristic of legal reasoning in general. Given the employment of casuistry in defense of torture, and given the administration's willingness to disregard existing legal strictures that prohibit torture, as demonstrated by the statement of former Attorney General Alberto Gonzales that some provisions of the Third Geneva Convention are obsolete and quaint, and the recent statement of CIA Director Michael Hayden that waterboarding could be used even if, quote, it is not certain that that technique could be considered lawful under current statute, end quote, opponents of torture might be tempted to abandon legal reasoning as they build their arguments. A popular alternative to the case-by-case, bottom-up nature of casuistry is the general top-down method of philosophy and the more abstract types of theology, which in this case would involve the quest for a definition of torture that would be capable of including almost any coercive interrogation practice that we might wish to prohibit. The hope here is that murky ethical situations may be clarified by the rigorous application of universal invariable principles. In this presentation, I would like to suggest that these strategies not be necessarily seen as mutually exclusive. Each approach has its strengths and weaknesses, and it may be that they need to be used in combination in order to be most powerful. As a way of illustrating this contention, I would like to examine a recent attempt to build a case against torture out of the sources of halakha, or Jewish law. Such a project involves an intriguing combination of legal and philosophical reasoning. Partially, this is necessary because the unique historical conditions of the formation of the halakhic corpus, namely the 2,000-year period of Jewish statelessness, have resulted in very little treatment of battlefield law or international statecraft in general, let alone the torture of unarmed prisoners in particular. This means that anyone committed to forming a position on torture that has halakha as its basis must begin by generalizing certain principles out of other areas of halakha that seem pertinent. A few methodological caveats are necessary before I begin. First, it is important to keep in mind that I'm not a posek or decisor in matters of Jewish law. I'm not here to tell you what Jewish law says about torture, but only to present one voice from a multivocal tradition. Second, as I just mentioned, the history of Jewish law in nearly all areas, including those to which I will refer in order to build a case about torture, has a fundamentally domestic orientation. The 613 commandments that are found by Jewish tradition in the Torah, whether they deal with the interhuman, bein adam lechavero, or the relation to the divine, bein adam lemakom, are directed to the Jewish people exclusively. The rest of the world is traditionally considered subject only to the 7 Noahide laws, the moral laws that are sort of naturally intuitable that, according to the Hebrew Bible, are incumbent upon the whole human race since the flood. Moreover, even the interhuman realm of the law deals primarily with issues that arise between Jews and other Jews, and the history of Jewish legal interpretation has taken place within a relatively enclosed Jewish society. This means that in order to apply halakha to situations that involve conflicts between Jews and some outside enemy, a universalistic assumption has to be made. One has to assume, in other words, that it is possible to map the domestic law more or less directly onto cases of conflict between societies, that there's not some whole other law or ethics that applies to battlefield relations with outsiders. This assumption, while necessary to allow a Jewish legal voice to participate in the conversation at all, should by no means be accepted uncritically as legally valid. I'll come back to that later. One perspicacious and thorough account of the position on torture in the Jewish legal tradition has been advanced by Rabbi Melissa Weintraub. During her tenure as Director of Education and Organizing for the North American chapter of Rabbis for Human Rights, Rabbi Weintraub produced articles arguing from halakha against the notion that torture or cruel, inhuman, and degrading treatment could ever be permitted as policy or a routine part of any interrogation program. She has argued this point on several different grounds, from the ban in Jewish law on self-incrimination to the supreme importance of kvod habriot, the dignity of created beings. For the moment, though, I would like to focus on her arguments with respect to the claim that torture may be necessary to save lives. Weintraub perceives rightly that this claim on behalf of torture is really a defense in the legal sense of the word, a post facto claim intended to exculpate the torturer. This makes it somewhat analogous to the rodef defense in Jewish law, the claim that one should be exonerated from an assault, even to the point of killing, because the victim was a rodef, or pursuer, who was chasing an innocent third party with the intent to murder them. The principle of rodef actually goes further, actively requiring bystanders to intervene when they can, and I quote Weintraub here, use preventative force to thwart acts of rape or murder transpiring before their eyes. The concern here is both to save the potential victim and to prevent the aggressor from transgressing a prohibition. This defense is one of only 3 exceptions to the otherwise absolute prohibition on taking life in Jewish law. The other 2 are self-defense and court-decreed capital punishment, each of which has a number of restrictions placed on it in its own right. And as such, this testifies to the lofty importance that halakha accords to pikuach nefesh, or saving lives in general. But as originally stated, the rodef defense pertained only to a situation in which one individual directly encountered a second individual attempting to kill a third individual. The law was expanded in its interpretation, however, to apply to more indirect situations, to the prevention of non-capital crimes, and to the protection of the public as a whole. To take a significant example from the previous decade, Yigal Amir, the assassin of Yitzhak Rabin, attempted to argue that his killing of Rabin was halakhically justified, since Rabin was a moser, or informer, who by negotiating to establish a Palestinian state became a rodef, who endangered the whole Jewish people. Most authorities rejected Amir's claim, but the fact that he made it at all shows the danger of allowing any legal exceptions or shortcuts to due process. The ancient sages were aware of this, as Weintraub argues, and thus they endeavored to place a number of important restrictions on the application of the rodef principle. There are 3 primary restrictions on the application of rodef. First, that force must be intended to save a particular victim from imminent and probable harm. Second, that rodef cannot be used to justify harm to third-party innocents. And third, that the rodef must be thwarted with minimal harm proportional to the threat that he poses. Weintraub deals with each of these restrictions in turn before asking how they might apply to the interrogation of U.S. detainees in Iraq, Afghanistan, and Guantanamo. With regard to the first restriction, that force may be employed only to save a particular victim from imminent and probable harm, the rabbis emphasize the spontaneity of such a situation. The intervention cannot be premeditated. It cannot be based on one's assessment of the prior conduct or future threat posed by the rodef, but rather must be in response to a pressing and present need. If the attacker one seeks to foil has already stopped beating the third party by the time one reaches him, for example, at that point, violence against the attacker remains assault and is not protected by the rodef defense. Preemptive strikes would also appear to be excluded. Halakhic authorities differ as to how certain one must be that the aggressor poses a lethal threat. For the most part, however, they acknowledge that although one must respond in the moment without full knowledge of the facts, nevertheless the evidence of threat must be very strong. With regard to the second restriction, that rodef does not permit one to save oneself or another by harming a third-party innocent, Weintraub cites the halakhic principle that humans are incapable of evaluating or comparing the worth of the lives of others. One life may not take precedence over another, as the Rambam has it. The Talmud, in its discussion of rodef, presents this story. Even as one who came before Rabbah and said to him, "The governor of my town has ordered me, go and kill so-and-so, if not, I will kill you." He answered him, Rashi, explaining Rabbah's idiom here, reads, "Who says your life is more beloved by God than his? Perhaps his life is more beloved." This principle extends into situations where we might be called upon to sacrifice one innocent life for the benefit of many. Only if that innocent would die in any event, for example, if the whole community will be killed, is it permissible to kill him to save others. If it would be possible to save him, martyrdom is preferable to the violation of the prohibition against murder. Who counts as innocent? The point is that this cannot be determined beforehand. Thus, there is a presumption in favor of innocence, absent strong evidence to the contrary, since, as Rambam says, quote, "It is better and more satisfactory to acquit 1,000 guilty persons than to put a single innocent man to death." There is a corresponding presumption against collective and arbitrary punishment, exemplified in the Bible by Abraham's argument with God over Sodom. "Far be it from you to do such a thing," Abraham said to God, "to bring death upon the innocent as well as the guilty, so that innocent and guilty fare alike. Far be it from you. Shall not the judge of all the earth do justly?" Finally, with respect to the third restriction, that the rodef must be thwarted with minimal harm proportional to the threat he poses, there are clear texts in both the Talmud and in the Shulchan Aruch, the 16th century law code accepted as authoritative by contemporary orthodoxy, that condemn the infliction of serious injury where moderate means would have sufficed. Weintraub notes here that even if one accepted the possibility of looser laws for the battlefield than for domestic crime, the interrogation room is different. It resembles domestic crime interrogation, since it involves the sober and prepared questioning of captive, unarmed adversaries. The heat of battle is absent, and excuses offered for actions taken in that heat do not apply. With these three restrictions in mind, Weintraub asks how they might apply to the situation of U.S. detainees in Iraq, Afghanistan, and Guantanamo. The principles of imminent harm and not harming bystanders would both appear to be violated by the empirical fact that thousands of people who are not on the verge of committing any serious crime have been detained at U.S. detention centers. They are often neither confirmed nor even suspected terrorists. Many of them were simply picked up in sweeps without due process protection and subject to guilt by association. The principle of spontaneity would additionally be violated by any authorization of coercive interrogation in advance as part of a deliberate, routine interrogation program. It cannot be argued that the widespread and well-documented use of techniques of sexual humiliation, offense to religious objects, placement of detainees in stress positions, deprivation of food and sleep, bombardment with bright lights, loud music, and extreme temperatures, and so on, have been spontaneous reactions to extreme ticking time bomb cases. Rather, it is precisely because interrogators do not know whether they have their man that they are resorting to force. They are gathering information, learning who belongs to what terror network, as well as generally punishing and intimidating suspects, precisely what is prohibited by the spontaneity principle. In the instance that a detainee is reasonably considered a suspect, in which case internment and interrogation in general would seem to be justified, the use of the aforementioned techniques would nonetheless be prohibited by the third restriction, that one must inflict minimal harm. Empirical studies and the records of FBI interrogators that show non-coercive techniques to be more effective than torture become relevant here. If an interrogator exhausted all possible non-coercive methods with a suspect of whom it was known for certain that they possessed knowledge of an imminent plot to harm many innocents, the true ticking bomb case, the principle of spontaneity would only retroactively provide a possible defense for an interrogator who lost control and used force on that suspect without prior authorization. According to Weintraub, however, the principle would maintain a hard line against the premeditated implementation into policy of such an exception. The crime of the use of force would remain a crime for which an ex post defense would have to be made. The principle of minimal harm is clearly violated, in addition, by the attempts of the Justice Department Office of Legal Counsel to classify cruel, inhuman, and degrading treatment as a kind of torture light that escapes being defined as torture. The administration thus seems to be trying to inflict as much harm as it can get away with, which is a far cry from inflicting the minimum possible. Moreover, since it is uncertain that the use of such techniques does not do more damage to U.S. interests and lives in the long run than the refusal to use them, through the acquisition of inaccurate information, the creation of widespread resentment of the U.S. around the world, the erosion of the image of our country as a moral nation, and the diminished expectations that our own soldiers will be treated humanely if captured, the standard of minimal harm is violated again. Domestic police departments, under the influence of a series of Supreme Court rulings, have long since been forced to get by without resort to the third degree, and have evolved other methods of questioning suspects that have demonstrated their effectiveness. One might interject here that the limitations on rodef discussed by Weintraub seem to apply to situations that involve the use of extreme physical force, such as could cause permanent injury or death, and thus that the restrictions might not apply to the various techniques of humiliation and pressure that the CIA and military have been using. It is at this point that Weintraub supplements her argument by incorporating analyses of Jewish legal positions on human dignity, public shaming, and self-incrimination. 2 points here stand out because I can't go into all of that in detail. The first is the seriousness with which the Talmud takes shame and humiliation, claiming that anyone who shames his fellow in public, it is as if he spilled blood. The second is the Jewish tradition's total ban on confession, in contrast to the weaker American restrictions on self-incrimination. It has been argued plausibly that the historical origins of the Jewish ban on confession as evidence, in a period when Jews regularly suffered torture at Roman hands, signal an intent to prohibit Jews from ever using torture themselves as a means of extracting confessions. But I'd like to move now from the content of Rabbi Weintraub's argument and of the halakha itself into a more formal discussion. Rabbi Weintraub's style of reasoning may be characterized as broadly casuistic, but with additional philosophical elements. She begins with an unstated conviction that God has created all human beings in his image, and that the Jewish tradition constitutes a divinely inspired conversation about how to live in light of this knowledge. She argues largely within the conventional parameters of halakhic discourse, citing precedents and maintaining fidelity to recognized authorities, and using the kinds of qualifications and analogies that are offered by the legal sources themselves in order to compare specific cases with one another. Her thinking takes into account the present context of the issue, asking in what sense the law can apply given the facts that we actually have, and she comes to her position through a dynamic evaluation of the interaction of specific abiding principles with particular changing circumstances. Her papers on torture thus qualify as examples of Jewish casuistry at its finest. Of course, legal reasoning is always based on a value system, and it will continue to be a topic of argument among philosophers whether the values that form the premises for legal thought may be themselves scrutinized or assessed in any non-circular fashion. Underlying Rabbi Weintraub's discussion, we find an ultimate commitment to the values of human equality and the pursuit of peace. For the sake of these values, Rabbi Weintraub leaves unargued the important case that a realm of law originally elaborated about domestic crime can be equally applied to cases of societal conflict. She thus takes a kind of shortcut. She makes a philosophical supposition about the universality of the application of the law in order to avoid the monumental task of combing the whole history of Jewish law for resources with which to build a new legal view of global conflict from the ground up. Such a reconstruction would have to deal critically with ancient and medieval Jewish views on the value of non-Jewish life in general, before moving on to the difficult consideration of the value of that life in conflict situations. The move to avoid this for the moment can be justified only by an intuition of the urgency of the problem to which Rabbi Weintraub is responding. In the light of what has been said, it seems clear that the rationalizations for torture offered by Bush administration officials constitute not representative casuistry, but rather what Albert Johnson and Stephen Toulmin have called the abuse of casuistry. Their claims are reminiscent of the lax moral teachings of the 17th century Jesuits, which occasioned Blaise Pascal's furious satirical attacks on casuistry in general. Pascal's case devastated the reputation of casuistry for centuries by arguing that reasoning about possible exceptions to the universal moral rules of Christianity led inevitably to condoning the most offensive practices. And indeed, this seems at first blush to be what has happened in our day with respect to the justification of torture. The practical response, however, to claims such as those put forth in the famous Bybee memo or in Attorney General Mukasey's testimony is not necessarily to condemn them as Pascal condemned the Jesuits by invoking any abstract universal principle, but rather to point out that the specific flaws in their reasoning. As Johnson and Toulmin write, the distinction to be made, quote, is not between a high-minded ethics of pure principle and an inevitably debased morality of cases and circumstances. It is between good casuistry, which applies general rules to particular cases with discernment, and bad casuistry, which does the same thing sloppily. In the situation at hand, it seems that the administration has engaged in bad casuistry in a number of ways. It has made unjustified generalizations from exceptions by claiming that the ticking bomb case can be thought of as a useful paradigm to apply to the situation of detainees that do not resemble that case. It has exaggerated the differences between a paradigm case of torture, that which causes sustained and permanent physical damage, and its analogous cases of cruel, inhuman, and degrading treatment. It has failed to take into account all the circumstances that have a bearing on whether its own general principle, the protection of American lives and the American way of life, is being properly served by ignoring the political and historical consequences of the application of indiscriminate coercive interrogation. And it has overstated the certitude of its conclusions about torture's effectiveness in a few cases in order to justify the permission of coercive interrogation as a routine practice. One could unfortunately go on. Casuistry is about the analysis of complex cases in which layers upon layers of circumstances seem to distance a situation from a generally agreed upon paradigm case. Hard cases present the unscrupulous with opportunities to obfuscate and confuse, but they also present those of goodwill with opportunities to clarify. The halakhic development of the Rodef defense provides one example of how conscientious thinking can weave together general principles with the kind of complicated developments that occur in the real world. And the issue of torture today is ripe for such debate, since there are few harder cases than bloody conflict, which inevitably complicates clear cases of self-defense or the protection of others. The Bible itself makes note of this when it reports Jacob's reaction to his impending battle with Esau. Then Jacob was greatly afraid and was distressed. Rabbi Shabtai Bass comments on this verse that Jacob was not afraid because he was worried about his own life, but that he was worried that he would kill Esau's men. Even though Esau was coming to kill Jacob, and thus Jacob might have had no qualms about killing him first, there remains the restriction to inflict minimal harm. And now I quote from Rabbi Bass, "Hence Jacob rightly feared, lest in the confusion of battle he kill some of Esau's men outright, when he might instead have restrained them by merely inflicting injury upon their limbs." Yet in the end, there is no guarantee that the struggle to end state-sponsored torture can be won by winning an argument, regardless of what form of reasoning is used. It is left to every sector and profession to do their best with the resources at hand. It will be the role of lawyers to argue that the U.S. ought to apply its obligations under the 1994 Convention Against Torture and Other Cruel, Inhuman, or Degrading Punishment, including the Senate's caveat that it refer to conduct already prohibited by the 5th, 8th, and 14th Amendments, to apply those obligations to non-citizens interrogated outside the U.S., and to explain the expansive restrictions that such an application would entail. It will be the role of journalists to catalog and report on exactly what goes on in U.S. prisons, and to bring into the light what is done in the dark. It will be the role of philosophers and theologians to identify the abuse of casuistry involved in citing the ticking bomb case as paradigmatic in the U.S.'s treatment of its detainees, as well as the attempts to create shifting, unstable boundaries between torture and cruel, inhuman, and degrading treatment. And it will be the responsibility of all critical intellectuals and decent citizens to be vigilant, ensuring that the moral stakes of this issue do not recede from before the eyes of the American public, so that our best selves are not lost to the brutality of the logic of war. Thank you.
It was well put and concise, so we have plenty of time for commentary. We'll have to take 10 minutes. Go ahead, Joseph.
Okay. I sympathize with the restrictions on torture or cruel, inhuman, and degrading treatment cited by Sam Brody as proposed by Melissa Weintraub as applicable to the Rodef defense. The three restrictions are limiting the use of force to spontaneous situations, risking imminent and probable harm, not harming innocents, and minimal use of force proportional to the threat. Brody shows that at Guantanamo, none of these restrictions is observed. In particular, the ticking time bomb cases that are widely used to defend the Guantanamo policies are considered by Brody not a useful paradigm to apply to other cases involving the treatment of detainees, and by Weintraub to remain a crime with a burden of proof to be met that the use of force was justified. I propose to comment not to further elaborate the restrictions, but in support of limiting the relevance of the ticking time bomb case to the issue of whether torture can be justified either prospectively or retrospectively. What exactly is a ticking time bomb case? Brody's example involves the director of the CIA telling Congress recently that waterboarding might be used to help prevent, quote, catastrophic loss of life, unquote, of Americans or their allies. It is important to note that the prospective use of waterboarding is limited to protecting the interests of ourselves and our allies. In other words, waterboarding would not be used to help prevent catastrophic loss of life to our enemies or to neutral third parties. Some possible justifications for waterboarding would be indifferent or largely indifferent to the status of those whom we are saving, counting it as valuable or nearly as valuable to prevent catastrophic loss of life even for those whom we don't particularly like. But the justification of waterboarding for the CIA director is based more on limited loyalties than on human rights. It is helpful to learn from Brody that even if the ticking time bomb scenario cannot be ruled out entirely, it does not follow that torture is acceptable in an environment such as that of Guantanamo, where preventive detention with less than full transparency and limitations on due process are taking place. And it is reassuring that in the framework of halakha, the use of waterboarding might have to be defended in court. If a case did come up in court, and especially if catastrophic loss of life had been avoided, there could be claims of mitigating circumstances, if not grounds for exculpation. But this leaves the ticking time bomb case still standing, like a boxer retreating to a corner but not knocked out. After all, it remains possible that after defending the use of torture in exigent circumstances in a legal setting, a torturer who tried to prevent a catastrophe will be exonerated. What more can be said against the implication of the ticking time bomb case that necessity not only makes torturers of good people, but that they may be heroes? For one thing, there is a difficulty in that it proves too much, and it could be used to justify more than torture. Few rights can be said to be absolute. Alan Gorth had to work hard to come up with the right of a mother not to be tortured to death by her own child as a rare case of a right that could be called absolute. But the argument for torture in the ticking time bomb case might allow for a contrived situation in which any right thought to be absolute could be overridden. Torture one's mother to death, and in so doing somehow save civilization. Well, let's not be faint-hearted here. Some sons or daughters might refuse to personally participate, but that just relegates the torturing to an unrelated member of our nation and its allies. Or better yet, outsource the torture and have it done for us by those whom we would not protect by using torture. Any way it is done, torture would have to be justified if it saves civilization. We might even have to learn to define a duty to torture. So there is a danger that any evil whatsoever can be contemplated, and no right is absolute once the ticking time bomb scenario is activated. Well, let's look at this ticking time bomb scenario from the hard-eyed perspective of the realist, who may be more risk-averse than others, and let's concede that someone may in fact be motivated to destroy a city over a cultural or political grievance or humiliation. We will show a difficulty that whatever actions we might take could be uncertain in their effects or counterproductive. Consider it in terms of probabilities. For any particular motivated person or group, the chances of being caught are good, so the probability of any single attempt destroying the city is not large. To get a wider perspective, this has to be multiplied by the number of cases that potentially may arise. This also is currently not that large. Suicide bombers increase the cost of deterrence, but they need to be recruited and trained to be effective, and those processes can be inhibited. Put it all together, and the probability of a city being destroyed may still not be large. But none of this is sufficiently reassuring that a realist with awareness of risk would not want to pursue greater security. One dilemma that seems insufficiently appreciated by policymakers is that security measures to reduce the odds of success for each particular attacker using aggressive techniques, trying to preempt attacks, when worked out on a global level, risk increasing the pool of potential attackers. The converse may admittedly also be true, in that focusing on broad policy measures to reduce the number of attackers might not lead to the most vigilant defense against each one. There is no guarantee of security, not even a reliable assurance of greater security than we currently have. If we compare the ticking time bomb case to something involving a natural catastrophe rather than terrorism, we can learn that our reactions are not necessarily in proportion to the actual risks of each type of catastrophe. It is well known that an earthquake could seriously damage many parts of the world where fault lines run. This could at some point be forceful enough to destroy a city, or at least paralyze it and destroy part of it. So the question is, why is it that all of us do not immediately demand that laws be passed to require construction to be 10 times stronger? And if so, why stop there? The reply is that risk aversion is a fundamental indeterminacy of irrationality, as shown by John Elster and others. The threat of there may be no answer to the question of how much security is ultimately enough. The threat of an earthquake is a ticking time bomb with no one to torture, but with ways to make ourselves more secure that we do not use or even consider. It may be that we underestimate some risks and overreact to other risks that are more salient in our imagination. And when we react to the risk of catastrophe caused by enemies, our thinking is shallow if the only way we interact with enemies is by torturing and killing them. The Universal Declaration of Human Rights says that not to be tortured is a human right. To protect that human right, it is necessary to defuse the ticking time bomb scenario, and I hope to have contributed to the case against torture presented eloquently by Sam Brody. What remains of the ticking time bomb argument? Saying that it proves too much and falsely justifies any presumed lesser evil than the one that is in focus may not change the minds of the torturers. Saying that preventative torture is counterproductive might not change the approach, though over time this realization might spread. Saying that there is no optimal solution to the question of how much security is sufficient may not reassure those who are risk-averse. Saying that the threat of terrorism can be compared to other types of catastrophe, but with the addition of a human adversary with whom we must interact, does not get us out of the situation, though with that thought in mind, we might be better able to moderate our response. Realizing that our fear of the enemy because of what might be done to us is connected with our fear of the enemy because of what we imagine ourselves doing to them could help lead to the necessary dialogue. Participating in this dialogue with our own government, living up to the human rights ideals that it partially and inconsistently proclaims, would be priceless.
I appreciate very much the form with which Sam Brody's discussion on torture status and halakha, or Jewish law, works. I think Brody's presentation illustrates the very real need for a clearer understanding of state intent. Dialogue on torture can hardly feel useful when the state is publicly declaring intent or an intent or an aim, quite different from what it actually seems to be acting towards. Brody's use of Melissa Weintraub's position on torture serves as an apt illustration of what torture can look like, depending on the value system that the legal reasoning is based on, depending on. And I'd like to underscore this point by describing how those values can are often not revealed in political discourse. Although acts of self-defense might seem simple, Weintraub's subtle understanding of these sort of acts raises the bar for a discussion on torture. In his presentation, Brody shows how Weintraub's argumentation is a combination of both casuistic and philosophical reasoning. She uses case-by-case reasoning along with certain assumed religion-based key principles. Though her argumentative moves are philosophically specific to the Jewish community, the intricateness of these moves shows how torture as an action towards another human is not as easy an issue. However, Brody points out, I think rightly, that argumentative ability alone cannot help end state-sponsored torture. As Brody adds, attempts at not letting the issue become logified are equally important. I am adding to that to do either, though. One might need to look specifically at the different value system that the Bush administration is acting upon, and which it does not ostentatiously declare. It is true that the argument put forward for its using torture is problematic in its construction, and it is also true that the fact that the torture's intended consequences are not achieved in all certainty does not help the argument. However, differences in value systems, differences which are not publicly acknowledged by the Bush administration, are perhaps more useful in bringing torture into a more accurate picture of the context in which it is being used. Considering the stakes involved in a dialogue on torture of human beings, the idea that state-sponsored torture is being described in terms of different ends than is intended becomes a problem. The torture's conditions in Guantanamo are not happening in a vacuum of power politics. Also, the stated end to save people does not seem to be the only end sought to be achieved. As pointed out by Brody, the decision to allow torture in what are supposed to be extreme cases are made for security reasons, to save lives. This kind of concern has many complexities to it, of course. A decision to save lives, in obvious terms, can involve other ends in mind. Other ends, such as establishing a future America free of terrorist acts, an end that would arguably need to consider different means, could also, or more prominently, be in mind as one saves lives. It might not even be an abuse of casuistry. Consider an example of the case that the Bush administration could make in private quarters, that extreme torture methods will, in the long term, put an everlasting fear in the heart of would-be terrorists, and therefore will eventually serve America and the world in the most effective of ways. This might actually be a feasible argument to groups of people whose sentiment and sympathies have been swayed by the newer sense of a shared American tragedy, i.e. the September 11th attacks. But considering that the U.S. also consists of people who will be equally appalled at such a claim, one cannot reasonably expect a public declaration of this kind of an aim. Considering these possible less public political aims that might not be declared, makes torture a logical follow-up to other laws which have in equal terms denied rights of prisoners. A particular stance seems to have been established towards would-be terrorists, which would make sense in broader terms than just in terms of reference to the prisoner's rights as a human right and the state's responsibility to protect its citizens. For instance, when the prisoner could not initially challenge his detention at Guantanamo, a right to habeas corpus taken away by the Military Commission Act of 2006, the cries against its unconstitutionality only received qualifications and justifications in kind. The rhetoric of a defense of a decision will pragmatically take different forms depending on the audience, but will predictably still try to be consistent with the values guiding those decisions. Even the actual torture even cannot torture a prisoner with conflicting feelings about his actions, nor can he torture while holding only those administratively phrased justifications. It's not that it's psychologically that would make little sense. What is presented to the public often has to be different from the totality of attitudes and values held. Brody concludes by describing the realistic attempts certain sectors of society can make in changing the meaning the state gives to torture. I think adding to this a more specific understanding of the rhetoric of power politics and the social psychological realities of these arguments might make the situation more clear and realistically, hopefully realistically changeable. A professor of mine once wrote on my paper commenting on my argumentative word choice, abstract language can sometimes be a form of injustice. Think about it. Relevant to all within which justifications for torture are made, this is a sound observation, if not about abstractions, because the Bush administration will not, the state will not use language that is abstract. Well, at least not obviously, but considering the potential covering up of a published intent over real and the more complex intent, a covering up which can abstract the situation can indeed be a form of injustice.
We do have some time for questions from the audience. I wonder, Sam, if you might want to spend a minute or so reacting. In particular, there were a couple of different ideas in play. One is that the arguments might be unpersuasive from the administration because they're simply miscalculations, but they're based on the appropriate principles or value structures. The other thought is, no, there are just conflicting or contrary value structures that are possibly in play. Joseph indicated that maybe those outside the U.S. or non-citizens simply don't count. And there's another possibility, which is that there's a distance between the arguments that are made in public, or that can be made pragmatically in public, and those that are actually animated in the administration.
Thank you. Yeah, I want to thank Joe and Ayla for the comments. I think it's, I don't know, my sort of...
Use the mic.
Use the mic. Oh. My kind of crude intuition is that Joe may be a little more absolutist than me, and Ayla may be a little more relativist than me. I'm not sure if that makes any sense, but I think that when it comes to the issue of argumentation and change, I mean, I think I mentioned in my paper that winning the argument might not be enough. You can win the argument in whatever way, and then people won't listen to you, even though you won, and they'll continue to do what they're doing, and you have to find some form of social action that will get the change that you want. So that in response to Joe's comments, I'm satisfied that the kind of presentation that I gave would exclude pretty much everything that the CIA and the military are currently doing that I don't like. And to imagine another situation in which they might do something else that I would like even less isn't really necessary. Whereas to Ayla's point, which is kind of the extreme emphasis on the fact that, well, maybe they won't listen to your arguments because they have private reasons that they haven't shared, I think my goal at least, was to present kind of publicly available resources for anyone who's interested in the issue to sort of combat the exactly the publicly offered reasons. And if you successfully combat the publicly offered reasons, then the privately offered reasons may have to then be offered, or they may not, in which case, again, the recourse to social action is what's necessary.
Questions from the audience? All right, then. Well, maybe we can have... Oh, I'm sorry. There is one. Very terrific. Go ahead.
Well, I really appreciated the talks, but I thought there was an equal amount of time given to the question of torture and the question of self versus other, or being versus who are. I wonder if you would explicate that more. Because it seems traditionally, at least these days, the way we think about morality is people can do more harm to themselves in terms of, say, how you treat yourself as an individual, suicide or euthanasia or what have you, or self-torture, than you can to others. And in this context, in the context of security and so forth, it works the exact opposite way. I mean, people always do more harm to others. How does that relate to the fact, to this distinction of self and other, and of course, also the distinction between responsibilities and rights imposed in the community itself, say whatever the 613 commandments versus 100, which is 7. Seems like there's a distinction there.
So what damage, I'm not sure if you could clarify a little, what damage to the self? You mean the damage that torture, if it were accepted, would do to Americans? Or
right. Would there be any distinction between how torture is justified or not in your own community versus universal?
Well, I think that the danger seems to be that the more that it's accepted as a sort of necessary thing that you don't like, the more it can kind of move over into some other sphere where actually it's good that we did it. And then there's a kind of a situation where the damage has been done to the point where you can't recognize that it was damaging anymore. And then that's when the others come and point out to you that you've been so damaged. I don't know if that makes sense to you, but it seems that it's possible for a country to reach a point where they're unable to see that what they're doing has damaged them precisely because they have been damaged by what they've done. And that's when some kind of either internal critique or somebody outside can point out to them what they've missed, because that they started out with sort of, this is necessary, I may not like it, but it's what we have to do to preserve our way of life, and then the way of life changes because you accepted that necessary thing.
All right. Well, thank you very much, Sam.
Thank you.
Garrett Ordauer and Kristen Love for commentary.
I just want to start off thanking Professor Anderson and Professor Nussbaum for putting this conference together, and Professor Samaha for chairing this section, and Kristen for her forthcoming comments. So I'm going to be talking today about private contractors and their use in war today, and what issues that raises in terms of torture and human rights abuses. So as some of you may know, there are as many, if not more, private civilian contractors in Iraq working under U.S. government contracts today than there are U.S. troops. There are more than 180,000 private contractors, and they usually perform everything from laundry to reconstruction to trucking, various things that used to be under the purview of the military itself. Those 180,000 perform strictly non-combat roles, although they may get caught up in things, but there are also an additional 50,000 that work for nearly 200 private security companies, and that number has grown steadily since the beginning of the war. Though those contractors are, in theory, supposed to engage only in defensive or non-combat operations, that's often not the case. In fact, 900 contractors have been killed in Iraq, and more than 12,000 have been injured, and those are numbers that do not count in the official tally of soldiers that have been killed or injured. One private security company reported 56 shooting incidents through the first 9 months of 2007, and those are self-reported incidents. And also, while required only to engage, as I said, in defensive action, private guards have gone so far as to issue combat orders to United States Marines. So to give you an idea as to the importance, relevance, and timeliness of this particular issue, I'm just going to give a few examples of where it's come up recently, and you all are probably familiar with some of these from the news. As Mr. Brody pointed out in his discussion of waterboarding, in admitting that the CIA had engaged in waterboarding earlier this month, General Michael Hayden also admitted that CIA contractors had engaged in waterboarding. Sure most of you are familiar with Abu Ghraib, but actually 10 out of the 44 specific allegations of detainee abuse at Abu Ghraib were directed against contractors. And in another well-publicized incident earlier this year, in September of last year, the FBI concluded that Blackwater, a private security company, had killed 17 Iraqi civilians in an unprovoked attack. In another incident, a Blackwater guard was accused of shooting and killing a guard to the deputy Iraqi prime minister on Christmas Eve 2006. So those are just a few of the many allegations against private contractors, but the commonality among them is that none has resulted in a criminal prosecution. So today I'm going to discuss the law governing these private contractors and specifically what laws apply when they are alleged to have engaged in torture or other violations of the law of war. Going to look at the impediments to the effectiveness of these laws and what gaps in laws exist. And though Secretary of State Condoleezza Rice has said that in her words, hole exists in U.S. law that has allowed these contractors and others to escape prosecution, I'm going to show that the laws do exist, but in the vast majority of cases, prosecutions have not taken place, not because the government is unable to pursue them, but because it is unwilling. Perhaps the most difficult issues, though, in this entire sphere are ones that have not yet come across the radar. Private military forces are expanding their scope daily. Some have proposed a private peacekeeping brigade and advertised soldiers for hire to be used in proactive rather than defensive engagements. Instead of static security, contractors are increasingly also being used in intelligence gathering, as we saw Michael Hayden admit. And while the current laws largely apply to U.S. nationals employed as private security forces, these forces are increasingly being recruited from foreign countries and often working for foreign governments and corporations. So I'm going to discuss what laws apply in those situations and where those fall short. Finally, I'm going to propose that an expansive legal regime be put in place to cover all contractors that have an affiliation with the United States, whether they are U.S. nationals working for the U.S. government or foreign nationals working under contract for a foreign corporation on foreign soil. So first, I want to talk about two statutory provisions that can be used when contractors are specifically accused of torture or violations of the law of war. The first is the War Crimes Act of 1996, which provides for prosecution of those who commit war crimes, including torture. In order to apply, the offender or the victim must be a U.S. national. And in addition, the Military Commissions Act of 2006 narrowed the definition of what offenses fall under this act. So, for instance, it wouldn't include things like outrages upon personal dignity of prisoners, which could be how you would characterize what happened at Abu Ghraib. Nevertheless, the War Crimes Act does appear to provide a powerful tool to prosecute private military forces accused of crimes overseas, provided that they or their victims are U.S. nationals. But the U.S. government has not to date had a single prosecution under the War Crimes Act. Another of these statutory provisions is the Anti-Torture Statute, which was implemented in response to the United Nations Convention Against Torture. The statute applies to anyone committing torture outside of the United States when they are acting under, quote, color of law, if the offender is a U.S. national or the offender is at any time present in the United States. So this could also provide a tool for prosecuting private contractors for torture, provided, though, that they are acting under color of law. It might also have an application in terms of going after private military corporations themselves for conspiracy if their agents are engaged in torture. To date, there's only been one indictment under the Anti-Terror Statute, and that's been for Chucky Taylor, the son of the former leader of Liberia, who was indicted in December 2006 for using torture against his father's political opponents. So these two statutes do provide a legal basis for pursuing torture charges against contractors who are either U.S. nationals, harm U.S. nationals, or are present in the United States. Not covered under these laws are foreign nationals working for U.S. private military corporations whose victims are foreigners unless they are present in the United States and had been acting under color of law. So before I discuss that situation further, I want to look at other laws that can be used to prosecute contractors for offenses that may not rise to the level of torture, but are nonetheless human rights violations. And also, for the purpose of this talk, I'm avoiding a specific definition of torture. That's obviously something that will be subject of much of the discussion of the weekend, and Mr. Brody touched on that as well. So the first of these is the military extradition Territorial Jurisdiction Act of 2000, otherwise known as MIJA, which provides for prosecution of those employed by the armed forces outside the United States for acts that, if committed within the United States, would be punishable by more than a year in prison. The act originally in 2000 only applied to Department of Defense contractors or subcontractors, which excluded, for example, the contractors employed at Abu Ghraib, who were working for the Department of Interior, and Blackwater employees, for example, who were employed by the State Department. The definition was expanded in 2004 to include contractors or subcontractors working for any federal agency or provisional authority, provided that their employment supports, quote, the mission of the Department of Defense overseas, which has basically been interpreted to mean that this would apply to anyone in Iraq or Afghanistan. There are acts pending in both the House and the Senate that would expand MIJA to cover contractors working in support of any military, quote, contingency operation. So that would basically expand it to cover anyone working for the military anywhere, for the United States military anywhere in the world. However, even with the proposed changes, MIJA does not cover U.S. or U.S.-funded private security contractors working overseas who are not directly working in support of a U.S. military mission. For example, people working for a foreign corporation in private security. It also wouldn't cover things like assaults by beating, striking, or wounding, because those might not be punishable by more than a year in prison were they committed in the United States. But to date, there have only been 2 prosecutions of contractors under MIJA since it was implemented in 2000. One of those was for a KBR employee who was charged for stabbing a fellow employee in the throat, and another contractor who pled guilty under MIJA to possession of child pornography. Another legal device that might be used is the Uniform Code of Military Justice, which provides for prosecution of those accompanying an armed force in the field. However, applying to UCMJ to civilians has been repeatedly held unconstitutional because of violations of various constitutional rights, including those to a grand jury indictment and a jury trial. Courts have further held that a civilian court could only be subject to a court-martial during a war formally declared by Congress, which of course Iraq and Afghanistan are not. In 2006, Senator Lindsey Graham changed the language of the UCMJ to include contingency operations so that it could be applied to Iraq and Afghanistan. Graham's stated intent was to expand the UCMJ to contractors, and in theory, this change would do that. But no civilian contractors have ever been charged under the UCMJ. No discussion of changing the law ever took place. The military has not attempted to implement such changes, and it's unclear, again, if they would ever pass constitutional muster. However, there does appear to be significant support for such a move from those in the military in order to maintain a strong chain of command and enforce discipline. For example, a West Point law professor recently laid out the case for bringing contractors under the UCMJ, arguing that, quote, "it is perhaps the first axiom of the law that like cases be treated alike. Soldiers and civilians accused of like misconduct in a like wartime setting should not answer to different courts, different procedures, and different law. However, even if such an application were constitutional, it is not clear that the UCMJ would cover contractors working for government entities other than the military, or whether it would cover those working for private corporate companies or foreign governments." One more statutory provision is the USA Patriot Act combined with the United States Special Maritime and Territorial Jurisdiction, also known as the SMTJ, which has historically allowed for prosecution of crimes committed abroad in places controlled by the United States, such as military bases, things along those lines. The Patriot Act expanded the SMTJ to include any buildings or land used by the U.S. government, irrespective of ownership. MIJA now appears to have a broader application than the SMTJ with the Patriot Act, but the SMTJ was used for the only prosecution to date of a contractor for violence against a foreign national. That was David Pizarro, who was a CIA contractor who was sentenced to more than 8 years in prison for beating an Afghan detainee to death with a flashlight over a 2-day period in 2003. So I want to discuss, as I said, Pizarro was the only prosecution so far since the beginning of this war and the Afghanistan war that has taken place. I want to discuss some of the notable prosecutions or would-be prosecutions that have not taken place and give some reasons why those might not have happened. So perhaps the most striking recent incident was the September 2007 Nisour Square shootings, which I mentioned earlier, in which a Blackwater convoy shot and killed 17 Iraqi civilians in what the FBI concluded was an unprovoked attack. Shortly after the shootings, under intense pressure from the Iraqi government to expel and prosecute Blackwater, is when Secretary Rice said that there was a hole in U.S. law that could allow the contractors to escape prosecution. A grand jury has since been impaneled to investigate the shootings, but officials connected with the investigation have continued to insist that there are legal hurdles to prosecution. They have also said there are significant evidentiary issues because FBI agents did not arrive in Baghdad until weeks after the shooting, and the vehicles Blackwater were using were repaired before forensic evidence could be preserved, which Blackwater said would have only been done at the direction of the State Department itself. Another I mentioned earlier, on Christmas Eve 2006, when a reportedly drunk Blackwater guard shot and killed the guard for the Iraqi deputy prime minister, Blackwater whisked the guard out of the country within 36 hours and fined him $15,000 for his back pay, or $15,000 in back pay. He's now in the United States. His name has been publicly stated at Congress, and it does not appear he'll ever be charged with a crime, largely because of the evidentiary issues involved. And then the detainee abuse at Abu Ghraib, again, 10 of the 44 accusations were against private contractors. None has been charged. In contrast, 11 U.S. soldiers have been convicted on charges related to detainee abuse at Abu Ghraib. Again, earlier this month, General Hayden contended that contractors who had admitted taking part, or who he admitted had taken part in waterboarding, he said are subject to the same laws as those governing CIA agents. But later, Attorney General Mukasey said that these allegations won't even be investigated. All four of these cases could have been prosecuted under existing statutes. The two Blackwater cases appear to clearly fall within MIJA jurisdiction, as Blackwater is working for a U.S. government entity, the State Department, to further the mission of the Defense Department in Iraq. And their crimes would be punishable by more than a year in prison. The Abu Ghraib contractors could not have been charged under MIJA because at the time it did not cover Department of Interior employees. But like David Pizarro, they could have been charged under the Patriot Act and the SMTJ. The CIA contractors that, if their conduct rose to the definition of torture and they were U.S. citizens, they could also have been charged under the War Crimes Act or the Anti-Torture Statute. In fact, many, if not most, of the crimes alleged against contractors do fall under some statutory provision currently in place. So looking at those laws that we've discussed earlier, it appears that Secretary Rice's comments about a hole is more an excuse for not prosecuting contractors than an explanation. The real hole in these situations appears to be the lack of ability or willingness to actually enforce and prosecute the laws that are on the books. The judge in the Pizarro case, for example, pointed out that if an autopsy had been possible, Pizarro might have been charged with murder instead of assault. Pending legislation, incidentally in the Senate sponsored by Senator Obama, attempts to remedy the enforcement aspect of this problem by creating what are called theater investigative units as part of the FBI that would investigate criminal allegations involving contractors prosecutable under MIJA. However, in the legislation, there is no funding provided for these units, and in order to staff these units at the same ratio as law enforcement officers to the U.S. domestic population, which would seem to be low because this is obviously a much more sensitive area, they would need about 480 FBI agents in Iraq. The FBI currently has about 12,000 agents total. So without getting into any more detail about this proposal, it does not appear realistic that the FBI could staff this project, could integrate it into the military, could operate without private security of its own in Iraq, or would be able to quickly respond to new areas outside of Iraq or Afghanistan that may need investigation. In fact, the original plan for the FBI investigation of the Nisour Square shootings called for Blackwater itself to guard the investigators. The FBI has also traditionally been a domestic enforcement agency and is designed as such. The courts-martial system, in contrast, has been tightly ingrained with the military for more than 50 years. The practical impediments to prosecutions are at least as equally matched by the political impediments, and I don't want to belabor those, but having contractors off the books is politically expedient in that their deaths do not count in the official tally, their crimes may not be easily attributable to the United States, especially if they are never investigated. So by this point, some of you may be asking why Iraq or another host country does not simply prosecute contractors itself. In the case of Iraq, contractors are immune from prosecution under Coalition Provisional Order Authority Order 17, issued by Paul Bremer in June 2004. Similar, what are called status of forces agreements, exist in conflicts in order to shield the military and those supporting it from local prosecution. In most conflicts in which the United States, most if not all conflicts in which the United States is involved. In 2000, for example, allegations were made that DynCorp contractors were purchasing women as young as 12 to be used as sex slaves in Bosnia. Military investigators quickly decided that they did not have court-martial jurisdiction, and Bosnian authorities declined to prosecute, believing the contractors to be immune under the Dayton Peace Accords. Even when no status of forces agreements exist, host governments are often unwilling or unable to prosecute. Almost by definition, private security contractors are employed when the security apparatus of the state they are operating in is not properly working because of reasons that might include war, corruption, or natural disaster. So in situations in which neither the United States nor the host nation are able or willing to prosecute contractors, there might be opportunities for international action, but these seem slim and not entirely probable. The International Criminal Court cannot prosecute U.S. nationals because we're not a party, but could, in theory, have jurisdiction over other nationals. However, the crimes alleged would first have to be of serious international concern, which would include torture, and second, be committed as part of a plan or policy or as part of a large-scale commission of such crimes. That second criteria would appear to be difficult to meet in the case of private contractors, who often operate in very localized, specific circumstances. However, the principle of universal jurisdiction does provide for states to prosecute those who have committed war crimes, even though the state has no links to the perpetrator or victim. This, for example, is the theory under which charges have been sought in Germany against Donald Rumsfeld for the abuse of detainees at Abu Ghraib and Guantanamo. Those charges haven't been brought, but that's the argument for them. For lesser offenses, third-party states are empowered under international law to prosecute if, for example, the perpetrator or victim is a national of its state. But I want to back away from those sorts of mechanisms and instead concentrate on the responsibility of the United States to create a comprehensive legal framework for prosecuting these private contractors. I first want to expand the class of incidents that should be covered under this framework. The laws that I've outlined earlier apply piecemeal to situations in which the perpetrator or victim is a U.S. national, or when the perpetrator is employed by some U.S. government agency or subcontractor. Additionally, in cases of torture, U.S. jurisdiction applies when agents or those conspiring to commit torture are acting under color of law and are present in the United States. So I would propose that the class of contractors reached by U.S. law for torture and other crimes be expanded to include foreign nationals working on foreign soil with foreign victims, provided that they are working as either a contractor or subcontractor for a U.S. corporation. I would define a U.S. corporation consistent with U.S. foreign relations law as one either owned substantially by U.S. nationals, managed by U.S. nationals, or having a principal place of business in the United States. I would also expand the current jurisdiction of MIJA to include anyone, anywhere, working in any capacity for or in support of the U.S. government. So an example, and this might be a mouthful, but a private security company owned by a U.S. national employing a foreign national under contract to a foreign corporation accused of a crime in a foreign country against a foreign civilian would be covered. So the only nexus there being that the company is controlled by someone inside the U.S. Of course, in any such situation, it would be the prerogative of the host country to prosecute, but in the case of a failed or rogue state, the United States would be able to step in. I want to briefly outline the need for such an expansive measure. The use of private contractors has been expanding rapidly throughout the world. It is by no means limited, as I said before, to static security. One pretty amazing example is that in 1995, a private military firm called Executive Outcomes was hired by the government of Sierra Leone to fight off anti-government rebels because their security apparatus itself couldn't do the job, which it successfully did. Blackwater, for example, has worked for the United Nations in Africa, Middle Eastern Police Force, the Jamaican Defense Force, the Taiwanese National Security Bureau, and the Azerbaijani government, among others. And those are just the ones made public because they're governments. We have no idea what corporations they may have worked for. A top Blackwater executive has suggested that the company could create in his words, private brigade ready for deployment around the world, and has been actively campaigning for the first mission to be to Darfur. Blackwater subsidiary named Greystone, which is actually incorporated in Barbados, advertises, quote, turnkey security solutions for corporations throughout the world provided by, quote, a workforce drawn from a diverse base of former special operations, defense, intelligence, and law enforcement professionals ready on a moment's notice for global deployment. Greystone has used what are called briefcase recruiters to recruit people from locales, including El Salvador and Colombia, to work under layers of subcontracts in Iraq. Greystone not only advertises static security, but, quote, proactive engagement teams, who, according to one contractor, will do everything from special operations to rescue to ransom. As this contractor says, quote, you name it, if you got the money, they got the honey. And though incorporated outside the United States, Greystone is managed from the very same Virginia headquarters as Blackwater. Private security is also rapidly becoming private intelligence. In the United States, 70% of the annual intelligence budget, $34 billion, goes to private contractors. In short, private security and private intelligence are incredible growth industries. With the economies of scale involved, I see it as inevitable that corporations and governments throughout the world will increasingly employ private security contractors in increasingly sensitive roles. For example, the availability and efficiency of private contractors might change the cost calculus for corporations where hostile local populations have kept them from doing business. What the Pinkerton Detective Agency did during the dawn of the industrial age, private security contractors could do in the era of booming global trade. These situations are ripe for human rights abuses. When employed as intelligence operatives, there could be situations in which these private contractors engage in torture in the hopes of obtaining information for their clients. So I don't want to speculate on all the situations that might arise as this industry continues to grow. We've already seen that existing laws did not fully anticipate comparatively simple situations like civilian contractors working for the Department of Interior at Abu Ghraib. The United States has a responsibility to ensure that it anticipates all situations in which private security forces that it has some connection to might commit a crime, and to hold those contractors accountable for their actions. Such a step would set a precedent for the rest of the world that it should be doing the same with respect to its private security forces, and put such forces on notice that they are not to be used as a way around existing criminal laws and laws of war. Simply because acts are committed by a private contractor who happens to be a foreign national should not shield them from prosecution. If a comprehensive regime is put in place, it would ensure that prosecutions are not avoided because of a hole in the law, real or perceived, would make it clear that if prosecutions are not undertaken, it is solely because of the unwillingness to do so. Such measures, I believe, would also protect civilian contractors worldwide, specifically those from the United States, that they would not be mistaken for combatants or be the subject of retaliation from those who believe such retaliation is their only recourse because the contractors would otherwise be immune from any consequences for their actions. By allowing unaccountable, apparently unaffiliated contractors to operate with impunity in Iraq, the United States has helped to foster an environment of anarchy that has led to the deaths of tens of thousands of people. The death squads and other shadowy militias that operate in Iraq do not seem so out of place when companies that appear to an Iraqi equally shadowy and unaffiliated are funded and blessed by the U.S. government. Though I've outlined the existing legal regime and the one that I believe should be implemented, the complexity of such undertakings and difficulties in enforcement are obvious and potentially insurmountable. I think plainly the best solution would be to phase out the use of these private forces. Unfortunately, I do not see this as realistic. We've opened a Pandora's box, and the massive amounts of money generated by this industry will ensure that what has escaped spreads and multiplies. Our only hope for mitigating the potential damage is to ensure broad accountability and set an example for other nations to do the same.
I guess I've organized my comments into two parts, and first is an attempt to sort of maybe reframe the issue of why the Bush administration has this contradiction in terms of laws on the books available to prosecute torturers, but at the same time the Justice Department has refused to do so. So to begin, and then the second part actually I will suggest a couple of ways that you could supplement the regime that you've proposed. So to begin my reply, I would like to first offer two epigraphs. The first is from a December 2005 Harris poll, and unfortunately I couldn't find a more recent poll of 1,961 U.S. adults. And the second is from writer J.M. Cutsea's Diary of a Bad Year. I don't know if any of you have read that, but I would really encourage you to read it. So the first, 52% of all adults, and again these are adults in the U.S., believe that the use of torture is justified either often, that's 12%, or sometimes, 40%. 83% believe that the U.S. uses torture often, 17%, or sometimes, 66%. And the second, on talkback radio, ordinary members of the public have been calling in to say that while they concede torture is in general a bad thing, it may nonetheless sometimes be necessary. Some even advance the proposition that we may have to do evil for the sake of the greater good. In general, they are scornful of absolutist opponents of torture. Such people, they say, do not have their feet on the ground, do not live in the real world. Machiavelli says that if as a ruler you accept that your every action must pass moral scrutiny, you will without fail be defeated by an opponent who submits to no such moral test. To hold on to power, you have not only to master the crafts of deception and treachery, but to be prepared to use them where necessary. Necessita, is Machiavelli's guiding principle. Cutzea then goes on to describe what he calls a dualism in the modern state, and I think that Garrett captured this dualism with, the contradiction between the laws on the books and the failure to enforce those laws. This dualism, Cutzea says, appeals to morality, to religion, and to natural law as the ideological foundation of its existence, but is, quote, prepared to infringe any or all of these in the interest of self-preservation. As Garrett shows quite effectively in his paper, the current U.S. criminal statutory regime that governs torture may be, unlike, as we quoted Secretary Rice claimed, actually adequate to prosecute many of the private contractors who have used torture. And although the Bush administration has disclaimed the use of torture in its war on terror, it seems that the administration's line on, quote, the intelligence gained and the lives saved because of enhanced interrogation techniques, and as Garrett describes the Bush Justice Department's refusal to prosecute contractors, are justified in terms of necessita. Thus, the president, who said in a September 2006 interview with CBS's Katie Couric, "We don't torture," has promised to veto, and Garrett mentioned some of this legislation, intelligence authorization legislation that was actually just passed in the Senate this month that would require interrogators to comport with techniques authorized in the United States Army Field Manual on Human Intelligence Collector Operations. And these guide the standards in the Field Manual prescribe, among other things, waterboarding. This ban would begin to implement some of Garrett's proposals and would govern interrogations of people, and this is the key, people in the custody or under the effective control of an element of the intelligence community or instrumentality thereof, regardless of the nationality or physical location, where instrumentality is defined as contractors or subcontractors, precisely the class of people that are not being held accountable at any tier of the element in the intelligence community. In order to implement Garrett's expanded legal regime then, we find two related challenges in the rhetoric of Necesita and the view of Katya's caller on talkback radio or the Harris poll respondent. To return to Katya, quote, "The world is ruled by necessity," says the man in the street, not some abstract moral code. We have to do what we have to do. If you wish, as we do then, to counter the man in the street, it cannot be by an appeal to moral principles, much less by demanding that people should run their lives in such a way that there are no contradictions between what they say and what they do. Ordinary life is full of contradictions. Ordinary people are used to accommodating them. Rather, Katya says, you must attack the metaphysical, supra-empirical status of Necesita and show that to be fraudulent. And one way of doing this is to look for an analog in the past. When have we been able to show this argument that necessity is somehow fraudulent? And I heard an interesting analog the other day from our own Professor Stone that frequently the argument that a regulation on speech was necessary for the preservation of the U.S., particularly during wartime, was used and justified by this notion that it was necessary for the preservation. So one person burning a flag or one person speaking out against a war should be prosecuted, even though we have these principles that are contained in the Constitution about free speech. We can maybe see torture in a similar light. It's not a perfect fit in that although there could be justifications, as some have used, that a single incidence of torture that extracts a particular form of information from someone being interrogated, that somehow that's useful for the preservation of society or the civilization, is not necessary, that we need to attack that necessity and say that torture can never be used under any circumstances, rather than saying our morals are better than your morals in terms of our ability to weigh the value of the life of someone who's being tortured and the value of, quote, lives saved by the information extracted from using a torture technique. Second set of remarks is just to supplement the regime that you proposed. And I think that one of the big struggles here is to recognize that the legislation, any forward-looking legislation, would govern contractors from here on out. So I agree with you. I think that it's going to be extremely difficult to phase out the use of private contractors when that's a more, I think that's a key insight, when that's a more efficient use of limited military budget. One method that's been used to address torture after it happens is something that I think Justice Sachs will talk about this evening, the truth and reconciliation model, a model that brings together people, and this is outside of a courtroom, brings together a torturer and a victim of torture to talk about what happened. And I think that that type of remedy or type of restorative justice that would take place in such a conversation would be particularly well suited to a torture situation, because the act, and Elaine Scarry describes this in The Body and Pain, the act of torture, it uses the tortured, the victim, as a device or instrumentality of the tortured. So the body's own pain, the pain of the body of the tortured, becomes the weapon that the torturer uses to extract words from the victim or the tortured. So to bring those two people together to talk in a public forum in a way that would acknowledge that torture has taken place may be a way to supplement a regime that wouldn't necessarily apply to people who had been left out of a regime in the past. But again, I wanted to say just a fabulous job. I think that it's quite impressive, especially since you're in your first year of law school, that you have really exhaustively cataloged the current legal or legislative regime that's available. But thank you.
We have just a couple minutes left, Garrett, if you want to follow up with some remarks on this idea of supplementing the regime, and if you also might want to spell out a little bit, what is the mechanism by which it seems to be the case, as you assert, that military contractors receive less enforcement pressure than ordinary military personnel? And is the pressure on ordinary military personnel, do you think, adequate? And if not, would it not be subject, under your view, to some form of foreign prosecution? Go ahead.
Well, I think just with regard to the mechanisms being different, I think basically, if I'm understanding correctly, that comes down to an issue of the UCMJ being in place for people in the military, and essentially at this point, no legal regime being in place for people except for MIJA, which is, as I pointed out, enforced sporadically and from abroad, being in place for people that are not part of the military regime, despite the fact that they're operating alongside each other. Let's see.
So application of UCMJ then, in your view, to private contractors would solve the problem.
I think that wouldn't. Also, with regard to your second point regarding how that bears on people in the military, I think that there is, widespread anger from people in the military towards contractors because they do not have to operate within the same bounds of discipline that the military itself does, and the UCMJ is such an effective and important tool in the military because it can be used to enforce a chain of command, which is what keeps the military together.
I'm sorry, you mentioned that there were constitutional problems, but would they be solved if military contractors had to agree to abide by the UCMJ and go under its enforcement regime in exchange for payments from the U.S. government?
I mean, I think that's one of the considerations going on right now, and I truthfully don't know enough. You'd probably be much better able to answer that question. Whether you can give up a jury trial or something like that, whether you can opt out of something like that, I'm not entirely sure of. I know that there's been a lot of problems in the past, going back to one of the famous cases of trying to apply the UCMJ to civilians. That term accompanying the armed forces actually originally meant people who were spouses of people in the military, and that I think the famous case was a woman who killed her husband who was in the military, and she was brought up allegedly under the UCMJ, and it was found that she couldn't be, because the military system, and I'm not entirely familiar with it, but operates in an entirely different manner than the domestic criminal prosecution system. There's a lot of rights are curtailed. So, I mean, I think that's what most of the people in the military would like to see, and I think that, that seems to be the best solution. But among the problems, aside from the problems of whether you can allow people to voluntarily curtail their constitutional rights, which I think in most cases you can't, is also an issue that we've condemned other countries like Pakistan, for instance, for putting their nationals under military trials. And it's something that the United States, I think, essentially sees as anti-democratic. And it's something that, I think it would be very difficult for us to reconcile supporting that with implementing it for civilian contractors.
Maybe quickly on Kristen's idea of truth and reconciliation.
Yeah, well, first I just wanted to say on the dualism, I think that this even the use of these even further distorts dualism in terms of the difference between the morality and the actuality of what's happening, in that we don't have to confront what these 50,000 security personnel are doing, because most of the time we don't really know about it. I think even here these examples are really the outliers, and I don't think we have a true idea as to the cost of what's happening. So obviously I think attacking necessity is what will eventually do it, but I think we'll better be able to do that if we show what's actually happening, which with these people in place, it really creates a problem of, I guess it would be like an externalities problem, where these costs are being exacted without reflecting on us. But with the truth and reconciliation, I think it's a great idea. I think that practically, if any of you have watched any of the congressional testimony of Blackwater or others, these people are not particularly forthcoming, and I think the chances of getting, first of all, I mean, obviously this is all happening very far away. I believe the reconciliation commissions have largely been used when it's something that's happened in country.
Yeah, I guess I didn't mention it, but one case that I'd point to is El Salvador, where private military contractors were used, and that was a huge challenge to bring them to the table, and I think that that's very true. But I would also say that Iraqi police themselves have been accused of using torture, right. So it may be a way of addressing systemic problems.
Yeah, no, sorry.
I'm sorry, I think we should wrap it up here.
Okay.
But thank you very much for this.
Well, thank you.